el silencio y celebrar la verdad.
El Salvador is one of the smallest and poorest countries in Central America. In the 1990s, after a long, devastating war, the new democratically elected government was desperate to encourage foreign investment. So it signed up to ISDS. For 5 years now, El Salvador has been fighting an ISDS claim. It's about gold and a foreign company's rights to mine it. The story started when pollution from old mine workings triggered a national scare about threats to drinking water, which spread to a community near the company's proposed mine. Pedro Cabezas, an environmental campaigner, was there at the time.
The community began to get concerned, and the protest that began in the communities spread through the cities as well. People came out with marching bands. We had high school students that came out, mothers and children, families that came from the communities. It was a festive atmosphere.
In response to public concern, the government suspended the issuing of all mining permits, pending an assessment of environmental risks. That was obviously a major setback for the Canadian company, Pacific Rim. Luis Parada, the lawyer representing El Salvador, acknowledges that this was a major change of policy.
It was actually in response to the people's concerns that the government became aware this was a huge issue that they had not anticipated.
So what did they say to Pacific Rim at that time?
Well, in May of 2007, they had a meeting not only with Pacific Rim, but probably 10 other mining companies. They told them without an environmental permit, there could be no exploration licenses or an exploitation concession.
Pacific Rim kept pressing for a permit, but a year later, the company's lawyer in the action, Timothy McCrum, says the outlook got even worse as an indefinite moratorium on metallic mining in El Salvador was announced.
In March of 2008, the former president of El Salvador made statements to the press that there would not be further metallic mining in the country. And those were simply press statements without any change in law or regulation.
But the point is, El Salvador says under its law, it's doing what its democratically elected government is allowed to do.
What you framed there is the issue that the arbitration panel will decide.
Pacific Rim spent tens of millions of dollars identifying their gold deposit. But El Salvador's lawyer, Luis Parada, says they're claiming far more than that in damages, $250 million.
The calculation was based on the assumption that they already owned all the gold that is still on the ground, extracted it, and sold it.
That's their projected profit.
So
if they'd got the exploitation concession, that's what they say they would have made.
Right. It is what they call their lost profits.
The amount of the Pacific Rim investment is in the tens of millions of dollars, but we believe the appropriate measure of damages is the value of the mineral deposit, which was blocked from development.
But it's still in the ground. You spent tens of millions of dollars. If you can't proceed with the project, that's what you stand to lose. But you're asking for this hugely greater sum.
That will be a question for the International Tribunal to decide.
In fact, the company behind the action is no longer Pacific Rim. In 2013, Pacific Rim sold its El Salvador interests to an Australian company, Oceana Gold, for around $14.5 million. El Salvador's lawyer, Luis Parada, says that deal amounts to a $14.5 million bet by Oceana Gold that the tribunal will award the $250 million claimed in the action. If Oceana Gold won, what would that mean to El Salvador?
It would mean a lot of money.
In fact, around 5% of the government's budget.
What Oceana Gold is perhaps hoping is that if it were to win, El Salvador would then offer them the concession instead of paying. It seems to me that it was an arbitration that was started from the very beginning with the intention to put pressure on El Salvador to grant a concession.
Arbitrators are expected to come to a decision any day now. El Salvador is a prime example of the kind of developing country investor-state dispute settlements were originally designed for. But as some wealthy West European countries are now discovering, stable politics and widely trusted courts don't prevent ISDS actions once a treaty's been signed. For decades, Germany was a leading promoter of ISDS treaties to protect its companies' investments overseas. But in 2011, that began to change.
Hundreds are dead, thousands have been evacuated from their homes as the most powerful earthquake to hit Japan triggers a tsunami across the region.
In the aftermath of Japan's Fukushima disaster, Germany announced it would phase out nuclear power altogether. As a result, Germany found itself being sued by the state-owned Swedish power company Vattenfall under a 1994 treaty designed to protect West European energy companies investing in newly emerging Eastern Europe. Swedish Vattenfall is certainly a West European company, but its target, Germany, is West European as well. London-based lawyer Matthew Weiniger says that's not what was expected when the treaty was signed.
It was not envisaged that the Western European nations would end up suing each other. Now, creative lawyers, as that case shows, have found ways of using the treaty to rely on claims between Western European nations.
I met one of Vattenfall's creative lawyers in the foyer of London's Smart Savoy Hotel. Kai Hober has over 30 years' experience of ISDS, acting for countries, investors, and sitting as an arbitrator. He insists that the ISDS system doesn't allow investors to stop elected governments carrying out their policies.
No one disputes today that the state has the right to regulate certain things.
But if they do, they have to pay the investor.
That may be the case, yes.
Well, that's a pretty compromised right.
Not necessarily. I mean, in the case of Vattenfall, for example, we are not disputing the right of the German government to regulate. They can do whatever they want, but there may be consequences. I mean, if you are an investor or a businessman, I think it's probably only natural to use all avenues that you can find to protect your investment and protect your business.
If you can, you do it.
Absolutely.
Doesn't mean it's right.
No, exactly. It doesn't mean it's right, and most tribunals say exactly that.
Germany's constitution protects private property. But because that protection is balanced by considerations of the general public good, any damages won in the constitutional court are likely to be far lower than an arbitration tribunal would award. But Kai Hober says Vattenfall's decision to use ISDS was more about trust than money. In a case like the Vattenfall case you're involved in, we're talking about Sweden and Germany. What's the problem with German courts?
Well, if you're a non-German investor and you have problems, so to speak, with the German government, I think most investors would prefer not to have your dispute resolved by German courts.
What, you think they wouldn't give a fair ruling?
I think that is the fear. I mean, perception is very important here.
Would you advise your clients that you'd better go to this mechanism than to the national court?
Yes, I would. You know, states are complaining about this, but they've signed up to these treaties themselves. If they don't want them, don't sign them.
Not all states did. Brazil has always refused to sign treaties with investor-state dispute settlement provisions and can still point to extensive overseas investments. And some countries which did sign are now pulling out. Post-apartheid South Africa passed black empowerment laws under which mining companies were required to share ownership of their operations with black South Africans. After an Italian company launched an ISDS action over this policy, in 2012 the government announced it would start cancelling the treaties it had signed. Peter Draper is a trade consultant and former official in South Africa's Department of Trade and Industry.
When the announcements were made by the South African Trade Minister that these treaties would be terminated, It was the Europeans, and particularly Karl de Gucht, who were very vocal in their opposition.
The EU Commissioner.
The then EU Commissioner, yeah, and accused the South African government of being irresponsible. He put a lot of pressure on the Department of Trade and Industry to change its mind. And then not even a year later, this debate started up in Europe about investor-state dispute settlement. So then our minister turned around and said, you see, we told you so.
So it's a kind of sauce for the goose, sauce for the gander here.
Exactly, yeah. But remember as well that South Africa has also been imposing these requirements on our African partners. We fought for a long time to get a bilateral investment treaty in place with Zimbabwe. Do we trust the legal system in the Democratic Republic of the Congo? I wouldn't, not even close.
South Africa isn't alone in wanting ISDS treaties with less developed trading partners, but not wanting ISDS actions to be taken against it. Historian Taylor St. John says the US now faces exactly the same dilemma with its fastest-growing trading partner, China.
Right now there's not an investment treaty between China and the US, but one is being negotiated. If, under that treaty, a large Chinese financial firm were to bring a case against the U.S. government, what would the response be of Fox News? What would the response be of the U.S. Congress? I once had an official tell me that he lost a lot of sleep thinking of the ramifications of a large case against the United States government.
In Europe, opposition to the proposed Transatlantic Trade and Investment Treaty, TTIP, and its ISDS provision is growing.
Give us the power to sue governments in corporate courts. Fantastic singing. I think it's really quite a momentous occasion that we've reached the TTIP.
Of the 150,000 responses to the EU's own consultation on the TTIP treaty, around 97% were against. In response to this opposition, Europe's new Trade Commissioner, Cecilia Malmström, is now proposing that TTIP should spell out governments' right to regulate in the public interest and exclude areas like health or environmental policy from the threat of ISDS action. Such a treaty, she told the European Parliament recently, could become a new gold standard, eventually replacing the current investor-state dispute mechanisms in thousands of treaties around the world.
The current network of agreements in place is not fit for purpose in the 21st century. We want the rule of law, not the rule of lawyers. And if we are to continue with investment protection and international arbitration, it has to be a different animal.
While opposition to ISDS has been intensifying, academic Lauger Poulsen has been asking companies how much the power to sue countries matters to them when deciding where to invest. He came up with a surprising answer.
When you ask foreign investors, they will give you a long laundry list of considerations that they take into account when they decide whether to invest in a foreign country, such as, are you close to a market? Are there natural resources? Is there a workforce that you can employ? What's the level of education? And so on and so forth. It is exceedingly rare that a foreign investor would consider to be crucial that there is an investment treaty in place before committing capital into even risky jurisdictions. It happens. However, we can be quite certain that they are the rare exceptions.
It's unclear where Europe's attempts to revise ISDS will lead. Some say the result may be no transatlantic treaty at all. But treaty or no treaty, what's clear is that ISDS powers in the over 3,000 investment treaties now in force will keep lawyers busy and governments worrying for many years to come.
That's the TTIP.
That was Michael Robinson. The producer was Rosamond Jones. And contact us on email, analysis@bbc.co.uk, or on Twitter @BBC Analysis.